What I want to do in the next 25 minutes or so is just to run through the evolution of the common law or judge-made law basis of consent, how it's evolved from Bolam in the 1950s to Montgomery in the present day. So we'll look at some key cases, and really the take-home messages at the end of the presentation are going to be that what we must impart to our patients are the material risks, reasonable alternative or variant treatments as appropriate for a reasonable person in the patient's position, and also that particular patient. So going back to 1993, this is a case that I think many of you will have heard of. This was a patient with chronic schizophrenia who was institutionalized, who had a gangrenous foot and was refusing amputation that was deemed necessary as a life-saving measure. So in court, expert advice was sought from a forensic psychiatrist, Professor Eastman in London, and he came up with what you will recognize as defining criteria for capacity. So here was an opinion in court before a judge, and this was taken to be so useful that it became enshrined in legislation, and of course is key to the Mental Capacity Act. So you can read the Mental Capacity Act in full if you Google it. And so that there is an example of how what started off within the common law became enshrined in legislation. And of course, the Mental Capacity Act is of key importance because it's setting out preconditions to allow us to treat patients in their best interests. So moving to ECT, and this is the ECT suite that has just come back into use this week. The problem has been lack of air changes down there, which has meant that ECT has been punctuating emergency cases at Queen's. And of course, the practice is tightly regulated, and we've got standard operating procedures meticulously written by Wing Commander David Evans. But back in the 1950s, it was a little bit different. Now I see that John Davis is on the call, and John is music guru, of course. And here we go, the top rock and roll hits in 1957 all shook up and a whole lot of shaking going on. So actually a couple of ECT anthems were around when the case of Bolam went to trial. Now Mr. Bolam in August 1954 underwent unmodified ECT. So he didn't have an anesthetic, he didn't have any muscle relaxant drugs, he was unrestrained on a couch, and he sustained horrible bilateral acetabular impaction fractures, and he sued. And the key point about this judgment was that the expert evidence was equivocal, meaning that whether or not a patient should be restrained or unrestrained to allow the seizure to exert its physical effects without restraint. Anesthesia was just coming into ECT then, and it may be a rather good thing that there was not many people dabbling in it in isolated locations who weren't trained. But the judge, Mr. Justice McNair, summarized that if you're looking at negligence in general, it's what the standard is what a reasonable man in the circumstances would do. Unfortunately, it's all male, it's a reasonable man. Yet if it's negligence in the context of people with specific training, working. It's the test as the standard of the ordinary skilled man exercising to have that special skill. And the test then is whether he has acted in accordance with a practice accepted as proper by a responsible body of medical men skilled in that particular art. And this endures to this day. Bolam's claim also included an allegation that he hadn't been warned of the risk of this terrible orthopedic injury. And an expert told the court that he'd seen only one acetabular fracture in 50,000 cases. It seems like there was an awful lot of ECT going on, because he was aware of 250,000 treatments and there'd only been one acetabular fracture. But the judge in 1957 said that if good medical practice did require a warning of the risk, the court would have to be convinced that the claimant would not have taken the treatment. So that was the standard in the 1950s. So then we fast forward to 1985 and the case of Sidaway. And Sidaway, Mrs. Sidaway, this was redo neurosurgery, and it was a C4 laminectomy and facetectomy for laminectomy. And she was paralyzed following this operation. The risk was deemed as being less than 1%, but she hadn't been warned of this risk. The surgery was held by expert evidence to have been non-negligent. So in the House of Lords, 4 of the 5 law lords stuck with Bolam from the 50s, and they held that the non-disclosure, because this Mrs. Sidaway was saying that she certainly wouldn't have had this operation if she'd been warned of the risk of being paralyzed. The non-disclosure accorded with a practice accepted as proper by a responsible body of neurosurgical opinion. And this afforded the defendant, as in the hospital, a complete defense to the claim. So Mrs. Sidaway, her claim failed. But there was one minority voice in the House of Lords, who was Lord Scarman. Now, he was more famous for Scarman report into the riots of 1981. But this was a minority view, and he was decades ahead of his time. He said he believed, in his speech in the judgment, the test is whether the doctor, in advising his patient, gave consideration to the right of the patient to make up her own mind in the light of the relevant information, whether or not she will accept the treatment which he proposes. And he introduced the term of material risk, that in the circumstances of the particular case, a reasonable person in the patient's position would be likely to attach significance to the risk. So we move now to a case that went to the House of Lords in 2004, but it actually, the clinical event was in 1994, and the expert for Ms. Chester was Mr. Firth from, some of you will remember from QMC. And it's another spinal case. I mean, we can see that spinal neurosurgery is fraught with potential bad outcomes. So Ms. Chester was a journalist, and she underwent 3-level microdiscectomies and suffered Corder-Quiner syndrome, and the risk was held to be 1 to 2%. Now, Ms. Chester was very honest, because she didn't say that if she'd been warned of a risk of Corder-Quiner syndrome of 1 to 2%, that she would never have undergone surgery. She was very honest and said that she simply wanted to think about it, and she would have delayed by a few days while she, as a journalist, rang a few friends in neurosurgery and sought further opinion. So it was accepted by the court that on a different day, on the balance of probabilities, she wouldn't have been injured, because if something has a risk of 1 to 2% and you have it in another day, you probably wouldn't have been injured. So this was a case that hinged on whether somebody should be compensated for something where there was proven causation that failure to warn led to her injury simply because a 1 to 2% risk eventuated on the day she had it done. And the House of Lords here are beginning to embrace autonomy and dignity, because they say that the right of autonomy and dignity can and ought to be vindicated by a narrow and modest departure from traditional causation principles. So it was accepted that the failure to warn hadn't actually caused the operation, but because she had not been afforded the right to come back on a different day, she ought to win the case and be compensated. But just as Lord Scarman had a very significant minority opinion in Sidaway, the minority opinion in Chester was Lord Hoffman, who's a big hitter in the House of Lords. And he compared this consideration of the risk of sustaining a loss, as in the injury, he compared it with the evaluation of whether or not you might win when betting, when gambling. And he said this argument is about as logical as saying that if one had been told on entering a casino that the odds on number 7 coming up at roulette were only 1 in 37, one would have gone away and come back next week or gone to a different casino. So there was a very strong negative opinion within the House of Lords. But we come now to the landmark case of this millennium, and this is the case of Montgomery, and this is the one that has precipitated the rewriting of the Association of Anaesthetists guidelines. And of course, here we are in an era of social media and Twitter, and Nadine Montgomery is very active on Twitter, and she'll follow you back and you can actually have a little chat with her, and she's more than happy because she's become an advocate of women's rights in obstetrics. And there's her pinned tweet here is where it says, having won this case, she then went to study law at Strathclyde in Glasgow. And here's this brilliant tweet where she says, "The awkward but proud moment when Prof McManus discusses your case in class." So she's snapped a picture of her case being presented to her tutorial group. So Nadine Montgomery is a lady of small stature, type 1 diabetes mellitus, had a big baby, and in 1999 had a sort of obstetric nightmare of a shoulder dystocia, symphysiotomy, forceps, and her son Sam was born with cerebral palsy, and the claim was she hadn't been offered the possibility of a caesarean section. And so this went from Edinburgh to the now Supreme Court. Of course, the Supreme Court has replaced the House of Lords. And this is the key bit of the judgment, is that the patient must be made aware of any material risks involved in any recommended treatment and of any reasonable alternative or variant treatments. The test of materiality is whether, in the circumstances of the particular case, a reasonable person in the patient's position would be likely to attach significance to the risk, or the doctor is or should reasonably be aware that the particular patient would be likely to attach significance to it. So distilling the key messages, and this was the sort of full big complement of Supreme Court judges, including Lady Hale, who's just retired. It's about material risks, reasonable alternative or variant treatments, a reasonable person in the patient's position, but also that particular patient. And the GMC was invited in as an intervener because it was recognized that much of what was going to be considered has already, 12 years ago, been set out by the GMC. So in fact, and many commentators have pointed out that although Montgomery is somewhat revered as a game changer, much of it has already been set out by our own regulator. And I don't know if you've all had the email from the GMC that this long-awaited revision of its decision-making and consent guidelines has been published, and it's coming into effect exactly a month from now. And having looked through it, I can't honestly see that there's anything revolutionary in here. They have set out 7 principles of decision making and consent, but there's nothing radically new in any of these 7 principles. So legal academics write and publish about judgments, and so the conclusion really on Montgomery is that it's eliminated this Bolam test. That is what that consent is no longer about just what a responsible body or reasonably competent practitioners would tell somebody. Bolam no longer applies to consent. That's Bells Hill Maternity Hospital, by the way, where Mrs. Montgomery had her son. And Lauren Sutherland, QC, those of you who are active on Twitter, she was junior counsel for Mrs. Montgomery, and so at L Sutherland QC, she writes a lot about this. And really, in summary, Montgomery is about the right to self-determination, that everyone has the right to determine what should be done with their own body. So that really is where we are now, as opposed to going back to Sidaway. The details of materiality, whether a risk is material, and this is something that comes up quite a lot, is people wonder, well, does 1 in 100 matter? Does 1 in 1,000 matter? The judgment does say that the significance of a given risk is likely to reflect a variety of factors besides its magnitude, the nature of the risk, the effect which its occurrence would have upon the life of the patient, the importance to the patient of the benefits sought to be achieved by the treatment, the alternatives available, and the risks involved in those alternatives. And I think a very important point for obstetrics, where we have women with dubious retention of capacity on nitrous oxide and filled with opiate who are pushed down the corridor towards theatre for the Category 1 section. The doctor's duty is not fulfilled by bombarding the patient with technical information which she cannot reasonably be expected to grasp, let alone by routinely demanding her signature on a consent form. And I know of at least one hospital in Kent where a consent form is not thrust in front of a woman and a pen put in her hand for the Category 1 section, because the validity of that action is highly dubious. And if you want to read more about this materiality, Nigel Poole is a QC who's just become a High Court judge, so he's probably going to have to stop doing his blogging. But he reviewed a number of cases since Montgomery and pointed out that a 1 in 1,000 risk may or may not be material, and it all depends on the circumstances. There is no statistical threshold for materiality that is universal. So Montgomery also talks about withholding information, as does the GMC. And I just want to dwell on one guideline, which has been, as far as I can gather, very poorly publicized within our trust. And this is a guideline about avoiding, diagnosing and treating well leg compartment syndrome. Now, the lead organization is the Association of Coloproctology, so it's colorectal surgeons. And of course, well leg compartment syndrome doesn't mean tibial fractures. This means people who walk into hospital have protracted surgery with the legs above the level of the heart. And the importance of this document is that it sets standards for consent and the prevention of the condition, but also what to do if it eventuates. So here is a specific reference to Montgomery, and it's a very good example of invoking Montgomery. But in the author's view, the needs and preferences of the patient should be considered so that where appropriate, for example, in an athlete or other active individual, a discussion satisfying the requirements of Montgomery can be undertaken and documented. So we don't have to discuss with every patient who's having a laparoscopic colectomy that they may have a devastating lower limb complication, but if it were somebody, a professional footballer or somebody for whom fasciotomy would be more disastrous than for everyone else, it should be mentioned. And these guidelines, and the barristers will seize on these because these are guidelines prepared by 4 professional bodies. It states that there should be a plan agreed before the operation, and here are the standards: that the period of elevation should not exceed, of the legs should not exceed 4 hours, and that legs should be lowered for a minimum of 15 minutes after each 4-hour interval. So this is going to keep a lot of cases out of court because it's so absolutely clear that if there's a claim, this standard can be referenced. And here's an important point, because I have seen a few years ago a case, not in Nottingham, where a patient in an HDU who was complaining of leg cramps after a laparoscopic colectomy, anaesthetic SHO was called to see the patient and prescribed some quinine. But here is a very clear statement that post-operative leg pain should raise the suspicion of lower leg compartment syndrome. And here, and again, as a clinical standard, it's a 4-compartment fasciotomy, and it should be underway within 1 hour of diagnosis. So here are very, very clear standards that have been set. So to sum up, we've talked a bit about the key common law cases that underpin consent, and that in this day and age, it's all about imparting material risks, reasonable alternative or variant treatments for a reasonable person in the patient's position, but also thinking about this particular patient. And there's nothing new about it. It's all encompassed in the 2008 GMC and the AGBI document. And thank you very much.